Thank you, Chairman Gowdy, Ranking Member Lofgren, and the distinguished members of the subcommittee for allowing me to speak before you today on the very interesting issue of birthright citizenship. Every year, approximately 350,000 to 400,000 children are born to illegal immigrants in the United States. To put this in perspective, this means that 1 out of 10 births in the U.S. is to an illegal immigrant mother. The executive branch automatically recognizes these children as U.S. citizens, despite the foreign citizenship and illegal status of the parent. And because the executive branch automatically recognizes them as U.S. citizens, they provide them Social Security numbers and U.S. passports. The same is true of children born to tourists and other aliens who are in the country in a legal status, but in a temporary status. It is unlikely that Congress intended such a broad application of the 14th Amendment Citizenship Clause, and the Supreme Court has only held that children born to citizens or permanently domiciled immigrants must be considered U.S. citizens at birth. Some clarity from Congress would be helpful in resolving this ongoing debate. In recent decades, the issue has garnered increased attention for a number of reasons. First is the mass illegal immigration this country has experienced. The population of U.S.-born children with illegal alien parents has expanded rapidly in recent years, from 2.7 million in 2003 to 4.5 million by 2010. Under the immigration enforcement priorities of the Obama administration, illegal immigrants who give birth to U.S. citizens have become low priorities for deportation. Furthermore, the President's DAPA program, the Deferred Action for Parents of Americans and Lawful Permanent Residents program, a program currently held up in the courts, would provide benefits to illegal immigrants who give birth here and allow them to, quote, stay in the U.S. without fear of deportation, end quote. That's from the administration. The broad interpretation of the Citizenship Clause forms the basis for these policies. Second is the issue of chain migration. A child born to illegal aliens in the United States can initiate a chain of immigration when he reaches the age of 18, and it can sponsor an overseas spouse and unmarried children of his own. When he turns 21, he can also sponsor his parents and any brothers or sisters. Approximately 2/3 of our annual immigration flow is family-based, and that's part of the reason, not the entire reason, but part of it. And this number continues to rise every year because of the ever-expanding migration chains that operate independently of any economic downturn or labor need. Third, the relatively modern phenomenon of affordable international travel and tourism has increased the opportunity for non-citizens to give birth here, raising questions about the appropriate scope of the Citizenship Clause. According to the Department of Homeland Security, in 2013, there were 173 million non-immigrant admissions to the United States. This includes people entering for tourism, business travel, and other reasons, but it also includes those who are engaging in birth tourism, which is a growing phenomenon that has arisen in direct response to our government's broad application of the Citizenship Clause. Birth tourism is a practice of people around the world traveling to the United States to give birth for the specific purpose of adding a U.S. passport holder to the family, while misrepresenting the true intention of their visit to the United States. An entire birth tourism industry has been created, and the phenomenon has grown largely without any debate in Congress or the consent of the American people. Birth tourism is becoming much more common with every passing year, and I do think at some point Congress will have to address it. Fourth is the sense among many Americans that the United States is falling behind the global trend on birthright citizenship, as many countries which once had such policies have ended them in recent years. The United States and Canada are the only two advanced economies, as rated by the IMF, to grant automatic citizenship to children of illegal aliens. For these reasons and others, there has been a bipartisan effort to end birthright citizenship legislatively, here, even in Canada as well. Multiple legislative efforts to clarify the appropriate scope of the Citizenship Clause have been proposed by both Republican and Democrat politicians, as there remains much debate about who should be considered subject to the jurisdiction of the United States. In 1993, Senator Harry Reid, Democrat from Nevada, introduced legislation that would limit birthright citizenship to the children of U.S. citizens and legally resident aliens, and similar bills have been introduced by other legislators in nearly every Congress since, I believe. Some clarification from Congress on this issue would certainly be welcomed and perfectly appropriate. I'd be happy to take questions on these and other issues. Thank you.